Who we got up first here?
We have,
Oh, that looks like a lot like my college roommate.
where's my biker buddy?
Oh, your bike?
I ride motorcycle with undercover police that looks like David Benner. Except they wear wife beater t-shirts. So that you can see all his tattoos.
Don't tempt him.
No, don't tempt him. We met Dave Banner. I met him for the first time when Jake brought him to a Chris Ann Hall event, and he was being dragged in here. Am I lying? You were being dragged there. You didn't want to be there, okay? And after he met Chris Ann Hall and heard her, something changed. And he started doing things differently. And we had him up to the stage here a year and a half ago. Is it almost a year and a half ago? Probably.
Yeah.
And when he stood on stage, his tattoos and his whole body turned white. He was kind of uncomfortable in front of people at that time. And I kept thinking, he's going to pass out. My gosh, what are we going to do? But he did it. And then as he's come to many tea parties and taught, he's become a consummate scholar and professional. And because of that, and because of the encouragement and his knowledge tied to our encouragement, he published this book. This is an incredible piece. Give him a hand. Compact of the Republic. If you haven't done your Christmas shopping, I'll tell you where to start. Right along here. Get the books, get Sheriff Mack's book. I'll talk more about Sheriff Mack's book in a minute. But I want you to give David Benner a warm welcome after this. Have him autograph this magazine if you're not a member yet. The magazine will cost you $5 if you're not a member, but it's well worth having the article in here. So please welcome our own David Benner. Come on up.
Thank you very much. So, I'm here and I'm pleased to share the stage with Sheriff Mack today, and I'm glad and grateful for the organizers that have chosen to have me today, including Jack, Gary, Kirk, Joel, everyone that's involved here. And I just wanted to say that I initially approached Jack and Jake and really, offered the suggestion that this event should be rebranded Sheriff Mack and the Tattooed Hack. Protect the Constitution, that'll work too. I can work with that. So, I guarantee I don't have the credentials of Sheriff Mack, but I don't think he has a Thomas Jefferson tattoo. All right? I could be wrong. He might shock us all tonight. But, all right, tonight I wanted to just speak a little bit about what I chose to write about in Compact of the Republic, which was finally published last month. And that is something that Ronald Reagan referred to in his first inaugural address. And that's that the states built the federal government. The federal government did not build the states. I wrote that this is a simplistic truth, but one that is often met with wonder or bewilderment. And that is because most people look at the United States today like it's a modern nation state. That's a nationalistic country where a centralized government essentially imposes its rule upon the whole country. Well, that's not the type of union that we're supposed to have. And I wrote that it is because most people's perceptions of the American Union is the way it is, that's why I wrote the book. And instead, the Constitution was sold as a compact, which is a multi-party contract amongst parties. In this case, the parties were the states. So the states entered into a contract with each other to create a limited government with defined purposes, not an arbitrary government that could possess every power whatsoever, not a government that was ratified by one people. No, instead it was ratified by independent ratification conventions within the respective states. Indeed, this is how the Constitution was sold from the get-go. Even people like Alexander Hamilton, who had nationalistic visions for the Union in Philadelphia, described the Constitution this way when he was selling it. This is what Hamilton said. Hamilton said, "There's nothing absurd or impracticable in the idea of a league or alliance between independent nations for certain defined purposes." So that's what Hamilton was saying in the ratification struggle in his own state of New York. That is written in Federalist 15. On the contrary to the nationalist view, the Constitution respects a collection of societies. That is a league of states. It's not a modern nation state. We should not share the same legacy as modern France or modern Germany. There, they had centralized authorities that created their government. No local districts were involved in the creation. Therefore, it's my contention, and this is what I try to prove in the book, is that the power that the federal government wields initially came from the sovereign peoples of the states. By virtue of being sovereign, they created this government for specified purposes. So we shouldn't expect the federal government to become Frankenstein's monster. We shouldn't allow or accept that vision. We should not allow the federal government to drag along the states like subjugated dogs on a leash. That's just not how we were meant to live. That's not the type of society that we are meant to have. And liberty, I think, is much more likely to thrive and survive in areas of decentralized authority and decentralized power. Well, I can tell you all this, but where's the evidence, right? Because I'd love for you to just buy whatever I say, but I'd like to actually give you some factual proof to back this up. Well, Madison referred to the states that ratified in Federalist 39 as 13 sovereignties that were entering into an agreement. In his state of Virginia, Edmund Randolph sold the Constitution as a document that was 13 parties to a compact. In the same state, George Nicholas said it was 13 individuals to a compact in which each individual's interpretation of the Constitution would be binding upon the other states. The Constitution itself acknowledges the states in the plural in every part of the Constitution's text. You can read that treason shall consist only of levying war against them, talking about the states, or adhering to their enemies, the states' enemies. In the same way, the United States shall protect each of them against invasion. It's just plain from the language of the Constitution itself that the states were pluralistic parties. It wasn't a national authority forming this government. It was written by a convention that took place in Philadelphia, but the Constitution had no legal bearing until the states considered it independently. In some cases, as in North Carolina and Rhode Island, those states decided not to ratify initially, until a few years later. The Constitution's preamble makes it known that the states decided on a more perfect union rather than a nationalistic state. A more perfect union is not a nation state. In the same way, our Constitution is divergent and incompatible with other countries in the world, like I mentioned before, such as in France, where the revolutionary authorities took control of the government and essentially took a proverbial eraser to the districts that had categorized the monarchical France. And then what they did was replace these districts with regions that were more convenient for them to be ruled by the centralized authority. The same happened in Germany in the 19th century, where Otto von Bismarck united all of the polities of the German Empire, all the polities into the German Empire, erasing their predefined powers up until that point. This is not the case with the United States. In the United States, the states sent delegates to decide these matters for the government. The founding generation was highly learned in the British constitutional tradition, and this, I believe, above and foremost, gave them knowledge that made them realize that local administrative authorities, and going all the way down to the individual, were necessary in order to thwart the power towards centralization. And in the book, I described that this, goes all the way back to the 13th century when King John was forced by the sword to sign the Magna Carta because his centralized authority was running amok. 400 years later, parliamentarians charged the king with creating a government of malicious and pernicious design, and eventually killed and beheaded him for creating a centralized rule and subverting the liberties of the people. 40 years after that, they expelled a king from their shores and replaced it with a joint monarchy, passed the English Bill of Rights, and made Parliament superior to the king. So this tradition is something that the founders highly understood. I'm ashamed to say I don't think many Americans do understand it today, but it made them convinced that local leaders and local districts were necessary to obstruct these treacherous and tyrannical tendencies. And learning from experience, we can see that this was one of the inclinations that the founders had when creating this document. Well, I'm pleased to speak today with Sheriff Mack, and I'm sure that he may talk about this, but Sheriff Mack instituted and initiated a successful lawsuit against the federal government in the 90s, for which he should receive much adulation. So, and I think that Mack's principles certainly align with this organization and what we're trying to do, because you can read this case, and it went to the federal courts and eventually the Supreme Court, the case of Mack and Prince versus the United States. Sometimes it's known as Prince versus the United States. I know Sheriff Mack has commented that, well, you know, why'd they drop the Mack? You know, I don't think they should have, but anyways, this case study is the most important in my estimation for anyone to read, the argument of Sheriff Mack's legal team, because it alleged that the federal government cannot commandeer the states to participate in unconstitutional actions. The federal government can pass legislation, but that doesn't mean the states have to follow in lockstep and participate in that garbage. And he proved that point. I think that it's among the most important cases to study in the 20th century, and it's a shame that it's not, it's not proposed as regular curriculum in law schools, that's for sure. At least law schools that believe in federal supremacy. And to end tonight, I'll just basically say that I think a lot of the problems that we have in government today are reflective of problems that Madison and Jefferson faced in the 1790s, because they faced a situation where they believed that the country was headed toward monarchy. The Federalists ruled and passed the Alien and Sedition Acts in 1798. But what I'll say is this, and I mentioned this in the book, I'm not a historian, I am a historian, I don't promise to have all the answers. But what I will say is that Madison and Jefferson did not submit to idle complaints. They did not sit on the sidelines and wait for the federal government to rule on issues. They didn't wait for the federal courts to weigh in on issues to determine whether or not they were constitutional. They did something else. And for the narrative on that, I'll refer you to my book. But as Jefferson said, nullification is the rightful remedy against federal treachery. So with that said, I'll be selling my book. I would love to sign it for you if you are interested. The price is $20. I can accept credit card, Visa, MasterCard, Discover, and American Express. I'll sign it almost any way you like, except I won't put like Nancy Pelosi rules or anything, I'm sorry. I have limitations too. I have my own internal constitution, right? But within reason, I'll do most other things. So really appreciate it. I'm looking forward to see what Sheriff Mack has to say. And Jack has allowed me to take, I think, a few questions.
I will be in the middle of the audience. We'll take 3 questions total. We'll take one over there, one over here, and one in the middle. And my question is, check. My question, I won't ask the question if you'll sign my book, say Going Bears.
No.
First question right here, in the middle.
Yeah, Dave, when you started studying on the Constitution, what did you study? What do you recommend everybody gets into besides your book?
Yeah, absolutely. I think the primary source materials have been completely overlooked when it comes to interpretations of the Constitution. Therefore, albeit as boring as it may seem, I think that the state ratification convention notes from the respective states are the best places that you can go to look at, how the document was actually sold to the people. Because you can see what people regurgitate, including myself, but you should check the source of what the states were considering when they entertained this. And Eliot has a fantastic version of the state ratification debates that is pretty prevalent and out there. But otherwise, modern constitutional scholars that I think do a great job are Kevin Gutzman and Tom Woods. So that's what I would say. Both of them have excellent books.
Right here.
You mentioned that nullification was the remedy. How do you propose we have nullification without common law courts, or how do you get the regular courts to listen to jury nullification?
Good question.
Well, jury nullification, I guess, would be a different principle entirely. I think that juries, and many of the founders, including John Jay, talked about this during the ratification time, believe that juries should not only consider the law itself, but whether the law should apply in a particular situation to an offender. When it comes to state nullification, the states can use their legislation, their legislative power as a bulwark, a shield against the federal government. And you may say, well, the feds are just going to enforce this, or they have too much power to enforce it, but not under cases where there's mass, interposition. Sheriff Max mentioned in the podcast today that James Madison, upon pernicious legislation, wished for the states to erect barriers against that kind of law. So the states can obstruct it. The states can order their state officials not to enforce this law, not to allow the federal government to have resources to enforce it. It can take kind of many shapes, but just, for instance, the states do not have to provide power to the NSA when the NSA enacts a surveillance state, for instance, so that's what I'm saying.
Final question right over here.
I'm sorry.
While everybody was watching the torture report release, the Senate passed an appropriations called the Intelligence Authorization Act of 2015. It was passed by a voice vote, so there's no record of who voted yay or nay, or how many people actually voted. There could have been 4 or 5 people in the chamber. How is that legal or legitimate?
Well, it is constitutionally legitimate, as kind of evasive as it may be, because the Constitution gives the Senate and the House of Representatives the ability to create its own rules. But here's the caveat, I guess. The Constitution also requires the federal government to keep a record of its proceedings and votes and things like that. So it's a situation, that one I don't know too much about, to be honest, but the Senate and the House of Representatives can make its own rules. But that's not to say I support, being, evasive about how you vote or trying to mask that. I'm for transparency, but, so.
Thank you, everybody.
Yeah, thank
Give
you
him a
very
big
much.
hand. Thank you, David.
One last thing. I wanted to really just thank all the Patriots here for their encouragement during the process that I was writing this book, because I assure you, without some of you, I would not have completed this work. So I really appreciate everyone here that's given me encouragement. Thank you.
Thank you, David. Homegrown in Minnesota. Wow. And he doesn't like the Bears, he likes the Packers. I'm digging that. Go Packers.